Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join us before we start. Good evening, everybody, and welcome to the Five Stone Buildings webinar program. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Whilst we're waiting for everybody to join us, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded and will be available on our website shortly after the recording has finished. If you have any questions throughout this webinar, please use the Q&A box at the bottom of your screen, and our speakers will try to answer questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speakers do not identify you in their response. And I will now hand over to Barbara Rich, Toby Bishop, Ruth Hughes and William East.
Thank you, Jo, and hello everybody. Thank you very much for joining us this evening. Now, the provisions of the Terminally Ill Adults End of Life Bill, more colloquially known as the Assisted Dying Bill, touch on areas in which we individually and collectively have professional expertise, both in the Court of Protection and in our practices dealing with inheritance disputes. And we know something of the people whose lives it's likely to affect, both as patients and families and carers, considering the choice offered by the bill, and people in the medical and legal professions. It's also, we're taking the opportunity to congratulate Ruth on her very well-deserved appointment as King's Counsel, excellent in itself, and also it adds to her weight as someone who filed written evidence with the Public Bill Committee and whose evidence was specifically mentioned. I happened to be at the committee in the public gallery the day it was specifically mentioned by one of the MPs on the committee, and by Naz Shah, who's been a very diligent scrutinizer of the provisions of the bill. And so, you know, very nice to hear a colleague mentioned in that way. And I immediately WhatsApped Ruth so she could download and clip the moment of posterity. We organised this webinar as, you know, taking a leaf out of the book of the popular podcasters who do emergency podcasts whenever something happens, as it does all the time in geopolitics at the moment, because we anticipated that the second reading of the bill, sorry, the third reading, would take place imminently this week. In fact, it has now been put back to the 16th of May, so there's less of an emergency aspect. And our intention is to be informative and not ideological, whatever our individual views of the merits of the legislation as a headline proposition are. But I think it may be helpful to delineate the divide between enthusiasts and what I call the secular skeptics of the legislation, because I think it explains a lot about attitudes towards specific aspects of the bill and their progress through Parliament. And essentially, as I see it, it's a divide about the exercise of personal autonomy and the nature of barriers to the exercise of personal autonomy, which are intended to prevent abuse of those who may lack personal autonomy. I'm going to say something a little bit about the progress of the bill and its nature as a private member's bill, and then also just comment specifically on aspects of the bill dealing with the test of mental capacity and the nature of some of the amendments that have been debated in the Public Bill Committee. And then I'm going to hand over to Ruth, who is going to talk about safeguards and their adequacy and some of the important changes that have taken place in the course of the bill through committee. And Toby and Will are going to talk about the succession aspects, and particularly something of which they have forensic experience, which is applications for relief from forfeiture of people inheriting from, for example, parents who have, under current law or absence of law, engaged in an assisted suicide. So the progress of the bill, second reading was at the end of November last year, carried by a majority, and went into committee, which started to hear oral evidence at the end of January, and then concluded its sessions just before Easter. Now, reflecting the majority of the votes at second reading, the majority of members of the bill committee were essentially pro the legislation, but with some fairly formidable forensic opposition, particularly from Danny Kruger MP and Naz Shah MP. And just mentioning those names, for anyone who's a political nerd, illustrates the extent to which there is no discernible, coherent political divide in the pros and antis. I can't believe there's a single other issue on which Nigel Farage and Diane Abbott both agree, for example, but they're both antis. Danny Kruger and Naz Shah come from very different strands of the political ecosystem, but they've, as it were, joined hands on this. And one of the things that has come out of the committee process is quite a lot of measured reasoned dissatisfaction with the progress of the committee and the way in which opposition has been voted down. And of course, that's fed into wider questions about the use of a private member's bill for a measure that's as consequential as this. And I mean, just sure it's not really necessary to recap this, but the core operative effect of the bill is to partially decriminalise what is currently a criminal offence, assisting suicide under Section 2 of the Suicide Act 1961. And the bill's promoter, Kim Leadbeater, and Kit Malthouse, who's very much a supporter of hers in the committee, and other MPs, very much object to the use of the word suicide, and they prefer assisted dying, and they seek to draw a kind of bright line between people in the wider population who generally, as a society, we strive to prevent from committing suicide, and these people who, in her words, are dying. But that's a separate debate about the use of language. The important thing is to understand that this is what the operative effect of the Act is. That's clear, but the precise shape or form of any state-enabled service of assisted suicide is much less clear, even at the end of the committee stage. Just a few words on limitations of private members' bills. Private members' bill doesn't have explicit government support or state resources devoted to it, either in preparatory work or in its progress. So it's introduced to Parliament with a lot less public scrutiny and consultation than a government bill. Now, we know it's public knowledge that this bill was drafted by retired senior parliamentary counsel Elizabeth Gardner, but effectively she drafted it with considerable expertise, but in a freelance way on Kim Leadbeater's instructions. And there was no pre-legislative work of the type that would be done for a government bill. It's also well known that both ministers of the principal departments whose work would be required to effect the provisions of the legislation oppose it. That's Shabnam Mahmood, Minister of Justice, and Wes Streeting, Minister of Health. And the junior ministers in their departments, Sarah Sackman and Stephen Kinnock, were members of the Bill Committee, and they voted with its promoter on all the amendments. One of the most acute deficiencies, I think, that's been revealed by the process is there's been no official work on resourcing state provision, either for the NHS to set up an assisted dying service, or for the courts, if that measure was to go through, to enable judicial oversight of assisted dying declarations. So it makes it difficult to get hold of the substance and understand what it would mean in terms of what is the state spending on what provision. And there's also a sort of sword of Damocles aspect to a private member's bill, because the government can block or hinder its progress at any time, and inevitably there's been speculation about this when the date of the third reading was put back. Is that the government's intention? What will actually happen to it? And hand in hand with that, the lack of parliamentary time for scrutiny, and if the bill runs out of time in this parliamentary session, it won't automatically be carried over to the next. So everything in terms of the legislative life of this bill is very much up in the air, and we'll have a greater measure of certainty after the vote on the 16th of May. Moving on now to mental capacity in the bill. As drafted, the bill provides in its headline clause a terminally ill person who has capacity to make a decision to end their own life and satisfies other eligibility conditions may be provided with assistance to do so. Clause 3 says capacity is to be read in accordance with the Mental Capacity Act 2005. Now, although the Mental Capacity Act has been in force since 2007, this would be new territory for its application as a threshold to formal validation of a decision taken by an adult with capacity, not as a threshold to a best interest decision taken by a decision maker on behalf of an adult who lacks capacity. And so taking the MCA test of capacity out of the framework of the MCA as a whole does take it into new territory and invites consideration of its suitability for this task. Not only its suitability, but the degree of practitioner familiarity with its operation. So for now, it's outside the zone of collective experience of the Mental Capacity Act. And I think that brings some conceptual challenges in its practical application. And the focus is on the part of the Mental Capacity Act test about capacity to understand and process information relevant to the decision. Information relevant to this dying decision is essentially existential. It's weighing up the quality of continuing or extinguishing life. Just very briefly on the existing jurisprudence, such as it is, over 20 years ago, in 2004, a local authority got an interim injunction and then asked but was refused permission to continue an injunction under the inherent jurisdiction to prevent a Mr. Z from taking his wife, Mrs. Z, to Switzerland for an assisted suicide. And there isn't any detailed discussion in that decision of the test of capacity to make that decision. A very eminent psychiatrist gave evidence. The court expressed fulsome gratitude because the evidence was accepted, and it was evidence that Mrs. Z had capacity to make her own decision and had done so entirely uninfluenced by anyone else. Sorry, bear with me. My iPad has just, sorry, my computer's just flicked over away from my text. Sorry. So there's no detailed discussion of the evidence as it was accepted. But there's a case which holds a closer mirror up to the world that may come into existence under the bill, is King's College Hospital NHS Foundation Trust against C, which is a Court of Protection case decided just under a decade ago in late 2015. Court of Protection had to consider whether a woman had capacity to refuse life-saving medical treatment. And in that case, the court recognised from the outset the value that society places on personal autonomy over medical treatment, and that it could only make a best interest decision for her if it found she lacked capacity to do so for herself. The context is very significant because the clinicians there were seeking a declaration of incapacity in order for the court to make what they and what many people would consider a better decision than they thought the woman was making for herself. And you may remember the very striking facts of this case. C was a middle-aged woman who'd attempted suicide. She was almost certain to die without renal dialysis. And although both clinicians and her family had tried to persuade the court that she lacked capacity to decide whether or not to consent to dialysis, they were unsuccessful. She had capacity, she refused treatment, she died shortly afterwards. And this was the woman who didn't want to live life without its sparkle. And the judge said she was a woman to whom the word conventional will never be applied. She'd led a life characterised by, this is the judge's words, impulsive and self-centred decision-making without guilt or regret. And she sought to live life entirely and unapologetically on her own terms, revolving largely around her looks, men, material possessions, and living the high life, premium on youth and beauty, living a life that sparkles. And so that's a rather tragic case, and you can read in it the striving, the well-intentioned striving to establish incapacity. And really, I think that's going to be the mirror image of how people will approach the capacity test under the bill. There'll be a striving to establish capacity. With that in mind, just very briefly look at some of the amendments that were considered and rejected relevant to the capacity test in the bill. There are a number of amendments intended to clarify the application of the bill to people with existing mental disorders. For example, limiting the circumstances in which people with anorexia might become eligible for assisted dying. And there was a general the majority of the committee opposed amendments which were promoted by those who believe that the mental capacity test is too limited, really, by comparison with the sort of assessment work that's done in suicide prevention, and the test really should be one of ability to fully understand assisted dying and its implications. Alan House, who's a liaison psychiatrist and who's one of the witnesses to the committee, has written in a recent article, "It has proved impossible to get the bill's supporters to agree any significant change that would require exploration of and a response to remediable psychological or social influences on the decision to ask for assisted suicide." Another amendment was proposed to raise the standard of proof of capacity to beyond reasonable doubt. And as I'm sure you all know, the Mental Capacity Act has a presumption, it operates on a presumption of capacity, which makes a lot of sense in everyday life. And the bill doesn't explicitly reverse this. In practice, though, will positive proof be required, and how knowledgeably and stringently will it be assessed? And I think the questions about the capacity test are very well expressed in the evidence that was given to the Bill Committee by a group at King's College concerned with complex end-of-life decisions. They say the mental capacity to end one's own life is a novel test in assisted dying law and policy. There is reason to believe it's the right test legally and ethically, and the public want it. However, it's far from clear that it can be reliably assessed or serve the public policy purposes of the Terminally Ill Adults Bill at this time. And with that, I will hand over to Ruth.
Thanks so much, Barbara. And first, I want to talk about why I'm really interested in the Terminally Ill End-of-Life Bill. And then I'm going to talk about what safeguards were originally proposed in the bill as first put forward by Kim Leadbitter, and how that's changed during the committee. And then I'm going to address whether I think that the changes are sufficient to make the bill reasonably safe. So the reason that I'm particularly interested in safeguards in relation to assisted dying is because a lot of my practice touches on financial abuse of the vulnerable and elderly. And I have seen many shocking cases of financial abuse where people have been stripped of their assets whilst alive and or persuaded, if not coerced, into making wills in favour of people that they might not otherwise want to benefit, to the extent that I am sure that if there is a act that comes as a result of this process, that the act will lead to the death of people for others' financial gain. Now, that might not be a reason not to have an act, because people who want an assisted death or assisted suicide might be sufficiently in need of assistance that it is worthwhile having legislation to help them. However, it is a real reason to think carefully about the safeguards that we are putting into this bill, and to be critical about whether they are providing sufficient protection for the people who are on the edge of the capacity threshold and possibly over it, and people who are vulnerable to pressure and coercion, or particularly if they feel that they are a burden in the world and the world might be better off without them. I'm concerned that people like that are protected in the best ways possible. So what safeguards were being proposed to begin with, and what remain? So consistently throughout the bill's life, there have been a need for two doctors to say that the person who wishes to die it has a settled intention of wanting to die, has capacity in accordance with the Mental Capacity Act test, and is not being coerced or pressured into making the decision to die in this using these methods. Originally, the bill drafted, which went to the second reading, had a fully judicial safeguard in that a decision of a High Court judge would be necessary in order to identify that a person did have that settled intention, that they met the other criteria in relation to the Act, which relate to, for example, age. You have to be over 18, and residence. You have to have been ordinarily resident in England and Wales for the last year, so there isn't assisted dying forum shopping, and also that there is no that there is capacity and that there is no coercion or pressure. I had concerns, which I expressed in my evidence to the Bill Committee, that these safeguards weren't sufficient. I was concerned about a lack of notice to people's family. It strikes me that when people are being subject to coercion and pressure, that they are unlikely to have all of the assistance of their family. They might be being sheltered from their other contacts, and that therefore a notification requirement was required. Otherwise, a rogue might come into the life of elderly or vulnerable person and assist them to die without their children or other family ever coming to know about it before it was too late. I have been concerned that there isn't a provision for someone like the official solicitor to act in relation to the cases that were going to come before the court in order to test the evidence, because the court doesn't have a properly inquestorial function, and it struggles to command its own requirement for evidence. It merely looks at what evidence, largely speaking, is put before it and makes a decision to see if that is the evidence supports the claim that's being made. Now, to a certain extent, these issues, but not wholly, are dealt with in some of the amendments to the bill. So, partly in relation to a concern that the judges had in the family division, that they wouldn't have the ability to deal with the cases that were likely to come before the court, and in part to do with concerns such as this. What is proposed after the Bill Committee's amendments is considerably different. So what is now proposed is that there will be a judicial commissioner who will be a High Court judge or Court of Appeal judge or Supreme Court or former member of those groups, together with a vice of the same standing, and they will commission panels of experts to make decisions in relation to whether people fulfill the criteria for being assisted to die. And those panels will include a legal member who will be the chair, a medical psychiatrist member, and a social work member. And they all have to agree that the criteria are fulfilled in order to have an eligibility certificate, i.e. to be able to continue through the process of being assisted to die. There's some significant lack of clarity about what the process for these sort of tribunals or panels will be. There's to be the commissioner's decision what procedure they will adopt. In general, they will sit in public, although they may sit in private in some circumstances. They must hear from the coordinating doctor who's coordinating the assisted death, and they will usually hear, except in exceptional circumstances, from the person who wants to die. And I do think that that is a significant improvement on the pre-existing draft, because it wasn't clear that the court was going to need to hear from the person who wanted to die previously, and I think that that will help to some extent in preventing coercion. There's still not clear that there will be any kind of notification requirement, and I think that that is a significant issue. This reflects also one of the problems of having a private members bill, because it's not clear what sort of regulations will be put in place. So it's clear that there will need to be training of the members of the panel, but the content of that training isn't wholly set out, and it's not possible to negotiate with the Ministry of Justice or the Ministry of Health to provide guarantees on what sort of training might be provided, although we know that it's going to have to deal with coercion and capacity, but the level of training is not yet clear. And also it's not obvious, and it's difficult to see how it would necessarily be funded for there to be someone like the official solicitor to have a properly inquisitorial role in challenging the evidence. It's also not clear how the proceedings are going to go forward if you want to challenge a family member's ability to be assisted to die. So, for example, if you find out that you think that someone is coercively controlling your mother and you want to put in evidence, it's not clear at the moment how that is going to be dealt with. Although, as the hearings are in public, it seems that it should be, at least in principle, possible to become aware of them and to make submissions to the panel members. I thought it was interesting that instead of finding some kind of way of having an advocate to the panel or advocate to the court, like the official solicitor might take a role in some cases, and I have acted for the official solicitor in that capacity previously, what there is in the amendments is the possibility of an independent advocate who might provide support to a qualifying person who has a learning difficulty or mental disorder under the Mental Health Act or autism, if they may experience substantial difficulty in understanding the process or information relevant to the process or communicating their views, wishes or feelings. And that struck me as potentially quite concerning, because I was concerned that if someone was going to experience substantial difficulty in understanding the process or the information relevant to the processes, then there was a serious concern that they would lack capacity. And I have some substantial concern about people being supported or pushed into giving a decision that they want to be assisted to die, particularly when they come from a vulnerable and disabled group. And it's been interesting to hear some of the disability advocates about how doctors may feel that their quality of life is not worthwhile, and that how that might cause doctors to present information that might be to lead people to want an assisted death that they might not otherwise want, and I think that is a concern that I do have. I think there are going to be some significant, interesting legal issues that arise from the establishment of these panels if they are enacted in anywhere near the shape or form that they propose. I think that it's going to be interesting to identify whether this legislation creates a carve-out at all from the Mental Capacity Act and the Court of Protection jurisdiction. So I don't know whether it might be possible to try and obtain a declaration in relation to a particular P that they don't have capacity to undertake these steps in relation to assisted dying from the Court of Protection, although it's possible that it will. And it strikes me also that there'll be a possibility of trying to obtain judicial review of the decisions of the panels which are formed. I think that whether or not these panels provide adequate safeguards is still very unclear. It's going to depend on the quality of the people on the panels, on the quality of the training, and on the rules which are set out by the Commissioner in relation to procedure, and in particular the ability of people to find out that their family who may be vulnerable or lack capacity are going through this process and object. So I think that the lack of clarity is a cause for concern still. But now I'm going to hand over to Toby and Will, who are going to talk about forfeiture issues in the current law and the potential future law.
Thank you very much, Ruth. Yes, exactly. That's what we're going to talk about. So the current law in relation to assisted suicide cases and the forfeiture rule, and then how the bill might change that. So under the law as it stands, the forfeiture rule applies to assisted suicide cases due to the criminal liability for assistance under Section 2 of the Suicide Act 1961. So unless relief is obtained under the Forfeiture Act 1982, a person who assists or encourages the suicide of another will not be able to benefit under the will or intestacy of that person. And in the House of Lords decision of Beresford and Royal Insurance Company Limited from 1938, the width of the modern principle of the forfeiture rule was expressed in the speech of Lord Macmillan, where he said that no court ought to assist a criminal to derive benefit from his crime. That case, however, shows the very different lens in which things have been viewed over the lifetime of the forfeiture rule. It involved a man, Major Rowlandson, whose money troubles were so great that he shot himself for the purpose of making the proceeds of his life insurance available for his debts. And the life insurance contract specifically provided for the insurance to pay out in the event of the policyholder killing himself more than a year after the inception of the policy. Yet, nevertheless, the House of Lords held that such a claim by Major Rowlandson's personal representative was barred by public policy. And Lord Atkin, in giving his speech in the case, quoted a book which described self-murder as being wisely and religiously considered by the English law as the most heinous description of felonious homicide. So that's just how far we've come in terms of attitudes to this sort of thing in the modern age. Now, in terms of the modern forfeiture cases involving suicide, a key landmark case was that of Dunbar and Plant in the Court of Appeal in 1998. It's not actually an assisted suicide case in the way that we would see them these days, but it sets out many of the key principles as to when relief from forfeiture will be granted. And Dunbar was a case in which the defendant was accused of theft by her employer and threatened with imprisonment. And she agreed with her fiancé that they would kill themselves together, but in the event she survived and he did not. And the Court of Appeal overturned the first instance decision granting only partial relief from forfeiture. And the court confirmed that the forfeiture rule applies to cases involving what was then termed, before the updating of the Suicide Act, aiding and abetting suicide. And there's important guidance within the judgment for all forfeiture cases. So Lord Justice Phillips held that the paramount consideration must be whether the culpability attending the beneficiary's criminal conduct was such as to justify the application of the forfeiture rule at all, and where the public interest required no penal sanction, it seems to me that strong grounds are likely to exist for relieving the person who has committed the offence from all effects of the forfeiture rule. Although Lord Justice Mummery in this case was in the minority on the result, the factors laid down by him that the court should consider are now regularly cited in forfeiture cases. So the court's entitled to take into account a whole range of circumstances relevant to the discretion in deciding whether to give relief from forfeiture, quite apart from the conduct of the offender and the deceased. So the relationship between them, the degree of moral culpability for what happened, the nature and gravity of the offence, the intentions of the deceased, the size of the estate and the value of the property in dispute, the financial position of the offender and the moral claims and wishes of those who would be entitled to take the property on the application of the forfeiture rule. Now, Toby's going to now go on and talk about the Ninian case in which he was involved, which was an assisted suicide case.
Yes, I'm going to talk about 3 assisted suicide cases in order to illustrate how they were approached both by the advisors, but also by the police, the DPP, and by the courts. So the first of those is Ninian, and that was the first. It was in 2019. It attracted some attention because it was the first reported judgment that I'm aware of, anyway, which involved a Swiss clinic suicide. And the man who travelled was a man called Alexander Ninian, and he was a thoroughly impressive person on lots of levels. He was a sort of captain of industry. In his retirement, when he was 80 old, he wrote a sort of an enormous thesis on sports marketing. And he first sought advice whilst he was still alive. He and his wife sought advice about their wills. So they had the benefit of quite sensible legal advice, both of them, from the outset. And so their solicitors sent them, their solicitors appreciated the potential problem that his wife faced, and so sent him to get independent advice. So after he had travelled to Switzerland and died, there was then available evidence from a solicitor who had met him and satisfied himself that that Mr. Ninian was acting independently, had capacity as far as the solicitor was concerned, and wasn't suffering from any sort of influence from his wife. On the contrary, he was the rather stronger character in the relationship. And there was also expert medical evidence about Mr. Ninian's capacity to reach decisions. And that medical evidence was produced by one of the sort of experts that we'll all be familiar with from capacity probate type cases. But medics have to be particularly careful about producing evidence which might be seen as providing some sort of assistance or encouragement towards someone committing suicide, because they're doing it in a professional capacity, and being paid for it is one of the factors in favour of prosecution in the DPP's guidance. So that particular expert will prepare a report but won't release it until after the person has committed suicide, if that's what they decide to do. So after Alexander Ninian ended his life in Switzerland with Dignitas, his wife came back and reported herself to the Met, and she was assisted in doing that by a specialist criminal solicitor, and that process highlights the importance of taking sensible advice as well, because the first criminal solicitor that she went to see told her you should not report yourself to the police. Nobody in their right mind who's committed any sort of crime goes and reports themselves to the police. There's obviously a slight problem with that advice, because she was about to go and tell a civil judge exactly what she'd done. And one of the factors in favour of prosecution, or one of the factors against prosecution, is that you have reported yourself to the police and fully complied with their investigation. So choosing to not do that is deeply unwise. So after she got sensible advice from a criminal solicitor, then she went and reported herself, and the DPP or the CPS considered it, and the DPP's nominee wrote an opinion about the evidential threshold being met and but it not being in the public interest to prosecute. And when the application was issued, it was heard by Chief Master Marsh, and Chief Master Marsh explained the sort of difficulty that the civil, or the unusual position that a civil judge finds himself in because of the interaction between the criminal justice decisions and the civil justice aspect of it. And Chief Master Marsh found considerable assistance in the DPP's guidance and in the opinion written by the DPP's nominee, taking into consideration all the different factors, and was keen to point out that what the court needs in these applications is absolute candour from those who have potentially committed a criminal offence and whose interests are potentially forfeit. And he found considerable assistance in that evidence from the independent solicitor, and the independent solicitor had also taken a witness statement from Alexander Ninian. So, of course, it's going to be of great assistance to a judge in a forfeiture case to have evidence from the person who went and committed suicide as to what it was that they wanted to do and the reason why the other person was helping them. And he found that Sarah Ninian had an extremely strong claim to relief, and he granted her absolute relief, but also added that these cases are invariably going to require a hearing. And that sort of takes me on to the next case that I was going to talk about, which is called Riel, which shows slightly different practice. That was another case which came before a master. It was an assisted suicide in a different Swiss clinic called Pegasus, but much the same. When the spouse returned, having assisted her husband to go and commit suicide, she reported herself to the police, and the DPP produced a similar report. when the master heard it, though, we'd asked for it to be dealt with on papers. The master said no, it needed a hearing because the chief master had said these will always require a hearing. But at the hearing, the master conducted it remotely and merely said that he began by saying, "I've read the evidence, I've read the skeleton. I intend to make the order unless anyone has anything else to say." That showed that some courts understand the sort of the sensitivity and the general the way in which these sort of cases can attract a lot of press attention, and which is very often very unwelcome to these families at extremely difficult times. And so the master was keen for that to not happen unless there was anything interesting about the case, and there wasn't anything interesting about that particular case, so he just granted absolute relief. And the other case I was going to talk about was Morris, which is a case that Will and I were in together. And that follows a relatively similar pattern. It's a Swiss clinic case. The family took advice before Mrs. Morris travelled to Switzerland. What's unfortunate for them was that the firm that they took advice from were apparently unaware of the concept of forfeiture or the need to seek relief. But the firm was aware of the risks of criminal prosecution. They were familiar with the Suicide Act, and so the solicitors who assisted them prepared their own evidence as to whether or not there was any undue influence going on. They wrote a witness statement addressing whether or not Mrs. Morris had capacity, and took a brief statement from her and statements from other family members. So that evidence was extremely useful. It was very unfortunate for the family that they were not told about forfeiture or relief before Mrs. Morris went and ended her life. When they returned, Mr. Morris reported himself to the police, and some police forces, what the desk sergeant told Mr. Morris was that there is nothing to report, and he persisted a little bit and said, "Well, I think there is. I'm aware that this is a crime and I have committed it, and so I'm here to tell you about it." And so they took him into a side room and they wrote him a note saying no further action. And of course, it's not really, there's only so far somebody is willing to press the police to investigate them for a crime, isn't there? And that was about as far as he felt he could go. So when he made his application, there wasn't the benefit of a report from the DPP's nominee about whether or not the public interest required a prosecution. But there was a note from a desk sergeant, which is of rather less evidential value. But the reason why that case is of some assistance to people is that in Ninian, one of the things that the Chief Master described as a fundamental act was the act of travelling. So Mrs. Ninian had travelled with Mr. Ninian. And so the Master, who first looked at the papers in Re Morris, took the view that the fact that the couple's children, adult children, had travelled with them meant that their interests may also be forfeit. And so for that reason, well, and the fact that all of the advisors to the parties disagreed with the Master on that, caused the Master to release it to a judge. And so it came to be heard by Miss Justice Trower. And Will was instructed to represent the interests of those who may benefit if the adult children's interests were forfeit. And so, Will, do you want to say something about the interests that you were representing and that aspect of the judgment?
Yeah, no, absolutely, Toby. So I was representing the beneficiaries next in line, as it were, after the children of Mr. and Mrs. Morris. And as you say, one of the interesting issues that came up was around the children having travelled along with Mr. and Mrs. Morris to Switzerland, and whether that mere presence amounted to assistance or encouragement within the meaning of the Suicide Act. And so what that engages is some of the criminal law principles as to what what encouragement or assistance consists of. And although it's not cited in the Morris judgment, I would suggest that the Supreme Court decision in the criminal case of R and Joji from 2017 is of some assistance. And that relates to the general law of secondary criminal liability. And interestingly there, the Supreme Court said that mere presence could amount to encouragement or assistance, saying both association and presence are likely to be very relevant evidence on the question whether assistance or encouragement was provided. Numbers often matter. Most people are bolder when supported or fortified by others than they are when alone. And something done by a group is often a good deal more effective than the same thing done by an individual alone. A great many crimes, especially of actual or threatened violence, are, whether planned or spontaneous, in fact encouraged or assisted by supporters present, with the principal lending force to what he does. Nevertheless, neither association nor presence is necessarily proof of assistance or encouragement. It depends on the facts. And in the Morris case, Mr. Justice Trower held that the act of accompanying someone to an assisted death can amount to assistance or encouragement. So the statute's really quite wide in that respect. But on the facts, the children, Katie and Jamie, had not provided any assistance since their father had made the arrangements for their mother's death, and they only reluctantly attended as comforters for their mother in circumstances in which they continued to offer her an alternative. So it's really quite interesting in terms of looking at what the scope is of the Suicide Act. And finally, the Morris case presented a little bit of a debate on how these cases are dealt with procedurally, because as Toby said, the view of those acting for both Mr. Morris and the children was that the interests of those next in line under the will were not engaged. So there was a question really about whether it had been right for the master at an interim stage to say that the default beneficiaries would need to be represented. Now, the view of Mr. Justice Trower was that a cautious approach is needed. And he said, paragraph 68 of the judgment, in my view, where an application is made for modification of the forfeiture rule in a case of this sort, and those next entitled under the will accompanied the deceased to the place where they took their own life and were present when they did so, the court will always need to give very careful consideration to the evidence bearing on the role which they played before satisfying itself that all necessary parties have been joined. And it would sometimes be difficult to reach the conclusion that the proceedings have been properly constituted without having a short directions hearing. And in my view, this was such a case. So that it did add quite considerably to the costs of the final hearing in Morris. But as Mr. Justice Trower says, you need to have a cautious approach and make sure that all the beneficiaries who might be affected are represented if that's necessary. I think, Toby, you're going to go on to talk now about the bill and how it might affect the position under the current law.
I am, but I just wanted to address a question that's in the Q&A box, which is probably relevant to what Will and I are talking about now. So it's an anonymous question. I wanted to ask this is the question. I wanted to ask what steps individuals who have assisted in a loved one's death, who have or have not self-reported to the police and received confirmation that they will not be prosecuted, then administering the estate themselves or via a solicitor without providing full details, without applying for relief from forfeiture law. I think that question, if I can sort of rephrase that question in an irritating lawyery way, if the police don't prosecute, can you then just disregard the potential that the interest is forfeit? I don't think you can. A couple of useful illustrations of whether or not the rule is engaged when there's not been a prosecution or even really an investigation are a case that Will mentioned earlier of Beresford. Well, that man shot himself. So he, of course, wasn't investigated or prosecuted or convicted of anything, but his interest was still forfeit. Perhaps even more relevant and poignant example is Leeson and Macpherson last year. Now, that's an absolutely shocking and harrowing case about a man who murdered his wife for money in Denmark. But he was prosecuted in England, and he was there was a half-time submission of no case to answer by his defence team, and the judge directed the jury to acquit, which they did. And then there was a civil application by the wife's family, by her son and some others, for a declaration that the husband's interest was forfeit. And the civil judge's judgment, it has a very thorough forensic analysis of the evidence available and reaches a very, very clear and firm decision that, in fact, the husband did murder the wife, and therefore the interest is forfeit. Now, so those two cases demonstrate a conviction is not necessary for the forfeiture rule to be engaged. And Leeson and Macpherson, demonstrate that even with an acquittal, that doesn't mean that the interest is not forfeit. It's a question in the administration of the estate, just like any other. Did the deceased have some other illegitimate child, or is their sister still alive, or whatever? It's just a question of fact, and either you can ascertain the answer sufficiently for those who have the duty of administering to make a decision about it, or you can't, and then you should go to court and get an answer. But hopefully that answers that question. To move on then to the likely impact, the bill doesn't address forfeiture head on, but what it does do is, in its draft form, it has section 24, criminal liability, providing assistance. Section 24(1), a person is not guilty of an offence by virtue of providing assistance to a person in accordance with this act. Now, that is not going to help very many family. That part of it is probably not going to help very many family members, because the assistance that's provided for mostly within the bill is assistance by medics or some other form of professionals. But there is an amendment which will introduce section 2AA to the Suicide Act 1961, which in its current form says section 2(1)A and 2(A)(1), a reference to an act that is capable of encouraging or assisting suicide or attempted suicide, does not include the provision of assistance to a person to end their own life in accordance with the Terminally Ill Adults Act. And 2, it's a defence for a person to show that they reasonably believed they were acting in accordance with the Terminally Ill Adults Bill, Terminally Ill Adults Act, and took all reasonable precautions and exercised all due diligence to avoid the commission of an offence. So aside from there being lots of questions and lots of scope for argument about what any of that means, it does seem to be suggesting that those who reasonably believed that what they were doing was in accordance with the act might have a defence, and if they make out that defence, then their interest won't be forfeit. But I don't think there are any cases that I have been involved in that have gone to the hearings or where I've given advice where the bill as currently framed would have assisted the people involved, and mostly that is down to the requirement that somebody can only rely on the act if their death is reasonably expected within 6 months. Most of the people in the cases I've been involved in are expected to live for at least years and sometimes decades. I suspect for most of them, if they thought they were going to die within 6 months, they might have just not gone through the trauma of travelling to Switzerland in the first place. So I don't think that the bill would have assisted anyone that I have come across. The question of whether or not those who assist or encourage suicide outside the provisions of the bill as drafted are more likely to be prosecuted is one that has come up in the committee stage. So Danny Kruger asked questions of Sir Max Hill, the former DPP, and also Sir Nicholas Mostyn, as in High Court Judge Sir Nicholas Mostyn, about whether or not people were going to be, were more likely to be prosecuted. And he was referring to an opinion by Alex Goodman, KC, on behalf of one of the campaign groups, Dignity in Dying, saying that people are more likely to be prosecuted if they go outside the provisions of this. Sir Max Hill said in response to that, I'm not sure about that. I would always default to the code for Crown prosecutors and the 2 tests that the prosecution must go through regardless of the crime that is being investigated. And then he went on to give some of his experience. I was often satisfied in the cases that I considered, and could often be satisfied in the future, that although the evidential test was satisfied, it doesn't always mean that a prosecution will result, because they must go on to the public interest stage. And he concluded his answer by saying that he'd gone through all that because it was necessary to consider the public interest stage. After a full investigation, it often transpired that the surviving relative had acted wholly out of compassion and, may I say, love for the deceased, and was not seeking any gain for themselves, far from there being any dishonesty before the act or after the fact. That would still remain the case. It does not follow that were the bill to pass and were people to take their elderly relatives to a dignitas, they would necessarily face prosecution. But the premise of your question is, could they? And the answer to that is yes. And Nicholas Mostyn, similar sort of question was put to him. He said, I do not agree. And he concluded his response to that question by, those who've watched any of the committee stage stuff know that it's a sort of particularly personal issue for Nicholas Mostyn. But he concluded by saying, if my children took me as far as Calais and then helped me after Calais, assistance only applies within the jurisdiction. So he's making a rather technical point there. But he's saying, and then they drove me on to Zurich, I'd be extremely surprised if any prosecution ensued. So their view seems to be that things will be approached in the same way. And I think that's probably right. Although I would have thought if this does become law, there will probably be a few reported judgments at the beginning whilst the court is figuring that out, because you would expect that there would be some updated DPP guidance about whether people should be prosecuted, because public, within public opinion, I think there is a fairly strong view that things have moved on quite a long way since the Beresford case that Will was talking about at the beginning, and that the law is out of step with what people should be permitted to do and the decisions they should be permitted to take in terms of assisting their family. But if Parliament has looked at that and has decided the parameters within which it can be done, and people then take a sort of Heath Robinson approach to it, I think that they are going to be looked at rather more carefully, at least until there's some sort of useful practice note from a Chancery Master saying this is how things will be done.
Thank you very much, Toby and Will and Ruth. We do have some questions, which one specifically about relief from forfeiture and relief from forfeiture applications. Toby's answered. First question is addressed, I'm going to read it out and then we'll do our best to answer. It's addressed to me and to Ruth. Rebecca Paul MP proposed amendments to add, quotes, undue influence and encouraged to the set of vitiating factors, coerce or pressure. The Minister objected to these on the basis that these are already covered by, quotes, coercion or pressure. Do you agree or disagree, or do you think that we cannot know for sure until it gets to court? I, speaking entirely personally, think that they probably are covered, and it's quite, to my perception, it's quite double-edged putting undue influence in, because undue influence, of course, a very long-established legal concept, but in its mechanical operation, for one thing, it's different, or its evidential operation is different in questioning lifetime transactions and in probate. So in terms of, in its context, there'd have to be some clarification there. And if asked to translate undue influence into modern colloquial English, I think I probably would say coercion or pressure. So that's my answer, but over to Ruth.
So I think the use of the word pressure is really interesting. In the Mental Capacity Act, undue pressure is used in relation to vitiation of lasting powers of attorney, and I think that pressure, without the word undue, could be quite light. And I actually think that that might be another way into the forfeiture problem, because I think that it might be quite difficult to show that you hadn't used any pressure, whilst it might not arise in relation to the panels if no one wants to say that there is any pressure being taken. I think that there's a risk that after people have actually died, that somebody who would benefit from saying that there was a forfeiture issue could make a claim for pressure, because pressure looks quite light without the word undue.
Toby or Will, either of you like to say anything about this? Should I go on to it?
I tend to agree with your view, Barbara, about that it's covered by the current wording.
Okay, let me go on to the next question, which is, re the panel hearing from the patient and the coordinating doctor, my understanding is that they only have to hear from them, which could be by email or an audio recording, but they do not have to see or question them. So there could be no testing of any evidence, including capacity assessment. Ruth, that's right, isn't it?
Yes, that is right, although it's more than there was previously, because they didn't even have to hear from the person under the original draft. I feel like that there's going to be some pressure on the panels to actively consider the evidence if it's going to be a useful safeguard at all. But I think that that's likely to arise in relation to the regulations or rules that the Commissioner will lay down in relation to the procedure. So I think that it's something that isn't entirely clear yet how it will be dealt with.
Mm-hmm. Right. Rupert Ticehurst has asked, is there evidence from the US states which permit assisted dying, e.g. Oregon, of abuse of vulnerable people? I note the assisted dying bill has stricter safeguards than those US states. And I think... Go ahead.
So I know that there is... so the thing that I know about Rupert in relation to this is anorexia, because there is some kind of troubling evidence that predominantly women are permitted to be assisted to die under the Oregon legislation, despite having a condition that is ostensibly treatable.
Can I add something, not in terms of US states, but in terms of Canada, where, amazingly enough, I think it was 4.7% of deaths in 2023 were assisted deaths in Canada. And there was an example from an official report in Ontario into the Canadian legislation, which talked of it's called medical assistance in dying there, practitioner driving a 40-year-old addict to his death after his psychiatrist suggested assisted dying as an option. And the report found that using their own car, so the practitioner's own car, to drive the patient to an external location to die by assisted dying may have created pressure and gave rise to the perception of hastening a person towards death. So in that case, you had someone who was actually involved in the system itself, who was found to have created pressure on the person to move forward towards assisted death. So it's not necessarily even just third parties outside of the system who can end up applying that sort of pressure.
And I know that there are cases, I think, under the Oregon and the Canadian system where assisted deaths are stopped as a result of the existence of pressure. But I don't know whether there are recorded incidents after the fact of people saying that they should have been stopped. I know that there are cases of people who have diabetes being said to have a terminal illness, even though, again, it is treatable for the purpose of assisted dying in other jurisdictions.
Thank you. Amanda Hunt has asked whether I or Ruth could talk about the case of people with dementia regarding capacity, and also briefly about the relevance of lasting power of attorney. On dementia, all I'd say is that as the bill currently stands, and with its incorporation of the Mental Capacity Act test, the test will be decision specific, and it will be, does this person have capacity to make an assisted dying declaration? Can they understand, weigh up and use, process and communicate information relevant to the decision? Somebody could have a confirmed diagnosis of dementia, but still pass that test if their dementia was mild. It depends, or if they were on a good day. I mean, obviously it's a very, very troubling area, but that's certainly my view of how the legality will operate. Please, if anybody dissents, speak up. Lasting power of attorney, I don't see something having any particularly close relevance at all. I mean, there is something we haven't touched on at all. Also, hasn't been time to deal with every important aspect of the Act. There is provision in the bill for proxies to sign the written declarations which form part of the mechanics. There is obvious scope to anyone who is familiar with this area of life and of law. There's obvious scope for abuse there. Proxies, the designation of a proxy, the statutory designation of a proxy, doesn't map onto an attorney under a lasting power or give them any special status, but it's clearly envisageable that that's the sort of person who might well act as a proxy. Ruth, over to you.
Yeah, so I agree that lasting powers of attorney aren't relevant, because if you are a principal giving a lasting power of attorney for property and affairs, then that just, that it doesn't arise. In relation to welfare, lasting powers of attorney for welfare only kick in once you've lost capacity, and once you've lost capacity, you won't be able to be assisted to die anyway under the terms of the Act. Now, there is a case which I think which was OPG reference about euthanasia and lasting powers of attorney, which our colleagues David Rees-Casey and Thomas Entwistle were involved in, where the OPG asked for essentially severance of wishes and feelings or directions in lasting powers of attorney for welfare that sought to allow, assisted death if that became illegal, and those were severed from the lasting powers of attorney as kind of contrary to the public policy and contrary to the inherent scope of a lasting power of attorney for welfare. And I don't see that this legislation would change that, because this isn't euthanasia for people that lack capacity, it's euthanasia or assisted death for people that have capacity and are making that settled choice. I unfortunately can't actually see the question boxes. How are we doing with questions, Barbara?
We've got a question from a doctor. You've discussed the issue about undue influence, but not the issue around encouragement. I'm very concerned that encouraging someone to seek an assisted death is not prohibited. I'm a doctor who'd be expected to conduct the relevant assessments. My understanding is I would not have legal grounds for denying an assisted death, even if there is evidence that the patient has been encouraged to take this option to save their family the nursing home fees, as long as that encouragement does not amount to pressure. Yes, I think I agree, that's a real concern. Any other views?
I agree with the doctor that it's a concern, but they aren't under a duty to provide assisted dying services, so they are able to take themselves out of the process without any concern for their own position. But if I were a doctor in that position, I would say that I didn't want to continue with the process, and I would make a note in relation to medical notes and ensure to ensure that the other doctors involved in the proceedings were aware of that, and equally the assisted dying panel, because that's something that might be a red flag for the assisted dying panel to engage in a closer scrutiny of whether or not there was pressure and whether there was essentially free and informed consent from the person who wanted to be assisted to die, ostensibly.
There's one question I missed as I was scrolling through. One final question. Is it not likely that the number of people going abroad for an assisted death will increase when the practice of assisted dying is normalised? Any views on that? Speaking for myself, I would say it entirely. I mean, one of my concerns, my personal opposition to the law is very finely balanced. It comes down against, because I think in society we shouldn't be normalising the sense of a duty to die. But I think the narrow answer to this particular question is going to very much depend on the availability of resources. How near is your NHS assisted dying hub, with some beige building that's owned Costa Coffee on the nearest bypass? And how long do you have to wait for an appointment? I think that's going to very much affect people going abroad. But I don't know what are the views of others.
Yes, I think it's fairly likely that as there becomes greater awareness of it as a possibility, then more people will go and do it. Although the numbers going to Swiss clinics are relatively high anyway. I was just trying to find some notes that I had about how many people had travelled to Dignitas. It's relatively. I remember being surprised by how high the number was. And Dignitas is one of only about 5 or 6 fairly well-established Swiss clinics that provide these services. And of course, Switzerland is only one of the many countries and jurisdictions which permit it to happen anyway. I think there's not. It's sort of underreported, mostly underreported. I mean, the number that I have somewhere, but I can't find at the moment, comes from Dignitas. But the advice that Dignitas were giving, at least up until the case of Ninian, was that people should not report this to anyone, as in the family when they come back. They should not report themselves to the police, and they should not go and see a civil judge about it. So for that reason, unless it was sort of campaigners who wanted to publicise the sort of availability of these services in some way, people were not reporting having done it. Oh, sorry, it's I'm away, I'm afraid. So my connection might be a bit slower than it should be. And I'll stop talking because it's very annoying when somebody. Well, it's very annoying when I'm talking most of the time, but in particular, breaking up.
When after the second reading, Esther Ransom was interviewed, and she said, I mean, really, I think it was astonishingly poor of the BBC to frame the interview the way they did. Obviously, Esther Ransom, to an extent, is BBC royalty. But after the second reading, she somehow seemed to have got the impression that it would make it the vote on the second reading would somehow make a difference to the legality of her family accompanying her to Switzerland. And I really think, on a serious news programme, she should have been challenged on that. And she said something about, well, I'll just be making arrangements to go to Dignitas, and my family will buy a cuckoo clock and some Swiss chocolate. Anyone who's actually been to Zurich recently will know that you're more likely to buy some pharmaceuticals and a reinsurance contract. But I do think, there's misinformation there that should have been corrected.
I also think that there's a macro point that actually comes back to something Barbara said at the start of the webinar, which is that like putting resources into an assisted dying service that isn't terrible, automatically will take it away from other areas of the NHS which are still in serious need of funding, and in
Or
particular,
palliative care, which is charitably funded.
yes, hospices, which are in fact largely privately funded through gratuitous donation. Like there is an element of a zero-sum game in a dignified death for people who want to have one without assistance, which is a concern to me.
I'm sorry to say, there's a bit of, to my perception, there's a bit of a sort of class of education divide between, there's a sort of sense of, oh well, you know, Zurich, it's the, you know, the sort of terminal fateful mini break where you go, and Julian Barnes, who's involved in Dignity Dying, has actually written an article in The Guardian about this, about how he'll visit the Zurich Kunsthaus to take his last look at paintings, his favourite paintings. You know, most terminally ill people are not going to be doing this. And the stuff like the chocolate and the cuckoo clock, it's all, you know, there is that sense of, well, it's there's a sort of a mini break aspect to which, you know, nobody's ever going to attribute to the NHS, the beige dying hub on the bypass. And I think it's unfortunate. People should be realistic about the implications of all of this. We've got some more questions. Somebody's made the point, re-encouragement and pressure, neither doctors or panel have a residual discretion to refuse if they find there is no pressure. That's right, and that's one of the things that has been an elephant in the room throughout the discussion about safeguards and about the judicial safeguard, which I described as like an ornament on the mantelpiece of the bill at second reading, and not quite as shiny an ornament when you get up close and start dusting it. Because it was always very coy about, well, you know, it's all very well having a High Court judge, but if you're not having the High Court judge do anything other than a sort of notarial validating exercise, so what? And yes, the heart of it is, this is introducing a process for scrutinising decisions taken by mentally competent adults and doing what? Notarizing them, really, not actually exercising any important jurisdiction to say, no, you can't do this. Somebody's commented, Anne Stanier has said 571 people travelled from Great Britain to Dignity House between 1998 and 2013. Somebody asked, my concern around encouragement is more for the patient than myself as the doctor. I might not want to proceed under this condition, but many doctors might if encouraging is not prohibited. Is there any legal reason why encouragement be prohibited? Anyone?
Well, I think it's the same point that we made before. If encouragement shades into pressure, then it's not permitted. Yeah. I think there were amendments that were tabled to stop doctors bringing it up of their own motion, and those amendments were rejected. That's right, isn't it, Barbara?
Yes, yes. And Anne says that the terminal date should have been 2023. And then Amanda Hunter says, read lasting powers of attorney. What about a family that holds LPA for health and welfare who disagrees with the capacity assessment that found the individual to have capacity? As their LPA doesn't kick in until incapacity has been established, this is concerning, as they'd have no means of raising concerns. The relative may have been cursed, for example, by an unscrupulous medic. Now, I think the answer to that is that their only means will be to apply for an injunction, which is not a sort of readily accessible everyday remedy, and indeed one thing that has not been talked about at all, even when the judicial safeguard was a live provision in the bill, is the access to justice aspect of who pays. And the cost of obtaining an injunction is quite significant.
Yeah, so I think it's going to depend. I've thought moderately hard about what I would do if I was advising someone in a similar position to this. And I think there are a number of potential routes, and it's going to depend on where you are in the process. So I do think that there might be scope for trying to get a declaration from the Court of Protection, but that's not going to stop your assisted dying process unless you end up with some kind of decision that you think is somehow res judicata. However, it might involve the official solicitor in acting for the person who might lack capacity, and then they might take some proceedings themselves in relation to the assisted dying process. You might be able to try and influence the doctors or the panel or even the commissioner, him or herself, in trying to put forward evidence and trying to join those hearings and trying to disrupt the process or put it on a proper track, depending on your point of view. Or you might end up trying to somehow judicially review the decision of the panel and fortifying that with an injunction if you're concerned. I think that's
very expensive, and you need access to solicitors who are going to be knowledgeable and act fast, and there's a lot of money.
Yeah, I agree with that.
Our last question is: the decriminalisation of the Suicide Act only applies to assistance under the Act, but not encouragement of assisted dying under the Act. So encouragement is a crime, but not a blocked eligibility. That's anomalous. Yes? Yes.
So the proposed amendment is in section 24, and it introduces section 2AA to the Suicide Act. So it says a reference in section 2 of the Suicide Act to an act that is capable of encouraging or assisting suicide or attempting suicide does not include the provision of assistance to a person. I see the points that's being made.
Yeah.
Yes.
Good point. Yeah.
It's an interesting point, but it's as you pointed out earlier, Toby, it is also a defence for a person charged with an offence that to prove that they reasonably believe they were acting in accordance with the Act.
Yeah.
And if encouragement is not prohibited under the Act, do you have a defence under that subsection? I'm thinking aloud here.
There's going to be a test case. That's all the questions we've had. Can I say thank you all very much for attending and for providing such good, interesting questions? Can I also apologise for speaking fast? We had quite a lot of material to get through. What we'll do, thanks to Jo, who's kindly done all the admin for this webinar, is, as you know, it's being recorded. We will put the recording on our website, and I'm certainly happy to tidy up my notes and put them there as well, and I'll see others if they are too. And I imagine we will email all participants once those materials are there. So hang on, I just saw one other thing flag up. Yes, Amanda says, from my experience, it's extremely difficult for families to contest capacity or incapacity assessment commissioned by social services. Capacity fluctuates in many cases. Yes, agreed. So once again, I think we'll end it there. And thank you all very much for attending, and hope this has been helpful to you. And all eyes on the 16th of May. Thanks.
Perfect. Thanks, everybody. Bye-bye. Good evening.
Bye.